All right, we're on record now. Case number 21 CR 24, Stablehouse versus Aaron Ludwig. All the jurors are present along with counsel and the parties. Thank everyone for getting here before 8:30, so we get started on time. So the state rested, the court admitted certain exhibits, and now we're on the defense case. Mr. Ring, your first witness.
Defense would call Aaron Ludwig.
Would you raise your right hand to be sworn, please? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Okay. I just have a seat over there. Counsel, would you approach, please? All right, you may inquire, Mr. Ring.
Aaron?
Yes, sir.
Could you state your name and address for the record, please?
Aaron David Ludwig. My address is 7925 Church Street, Highland, Ohio, 45132.
You're not residing at that address at this point in time, are you?
Not currently.
Okay. You haven't resided there for several months?
Yes, sir.
Okay. And Aaron, what's your highest level of education?
Junior in college.
So you graduated high school and did multiple years in college?
Yes, sir.
Okay. You read and write and you understand the English language?
Yes, sir.
Right. You understand that you have a Fifth Amendment constitutional right to elect not to testify in this matter. You understand that?
Yes, sir.
By testifying today, you're waiving or giving up that right. Is that your understanding?
Yes, sir.
Is that what you want to do?
Yes, sir.
Okay. Aaron, are you currently employed?
Yes, sir.
Where are you employed?
I work at Airborne Maintenance and Engineering Services in Wilmington, Ohio.
What do you do?
I'm a licensed aircraft mechanic. I'm a structures technician. I do heavy maintenance on Boeing 767, 757, 717s.
Can you tell? I don't really understand what that means. Can you break it down for me, explain it a little bit?
I perform structural repairs on these aircrafts, and there's zero tolerance for error. Everything has to be perfect. Hundreds of lives are on the line when these planes are flying. I have to do my job perfectly.
How long have you been doing that job?
Just under 5 years.
Okay. Is there any kind of specialized training or education requirements that you have to go through to be able to do this job?
I went through a technical course, 18 months, and obtained my license.
When you say obtained your license, did you have to take some kind of testing or anything involved?
There are 4 separate tests that I had to take to acquire my license.
Okay. And that took you 18 months to acquire?
Yes, sir.
So when you tell me that you've been doing this job for 5 years, does that 5 years, is that 18 months inclusive into the 5 years, or is that 5 years on the job and 18 months training?
It was on the job training.
Okay. Now, Aaron, you say that you were residing in Highland.
Yes, sir.
How long have you lived in Highland?
We moved in June of 2013.
Okay, when you say we, who are you talking about?
Marianella, Maxine, and Naomi.
Okay. Marinella, that's what you refer to as Marnie, is that correct?
Marnie, yes.
Okay. And have you been involved in your community at Highland?
Yes, sir.
How so?
I was elected to village council in about 3.5 years ago. I was appointed to the North Highland Joint Fire District by the village council at the request of the exiting mayor, and I served as a soccer coach for Maxine's soccer team for 3 years, or 3 seasons. Sorry.
What was that involvement with the fire department, or what exactly is that?
I was on the board of trustees.
Relevance of all of this?
Overruled.
I was on the board of trustees. We make financial decisions for the fire department, and we vote on things. And if there were issues that we had, an example is that one of the tanker trucks was leaking. It was going to cost $90,000 to replace. The company that manufactured the truck wanted almost $9,000 to repair it. I was able to get someone that was confined space qualified to come in and repair it for significantly less money. So I contributed in that way to that.
You also said you were a soccer coach?
Yes, sir.
Is that a volunteer position?
Yes, sir.
And that was for Maxine?
Maxine, yes.
That's your younger child?
Yes.
And when was that?
It was when she was in about first and second grade. It was practice 2 days a week, games usually Saturday and Sunday, traveling all over the region.
Were you the only coach, or were there assistant coaches?
I was an assistant coach. Her best friend's dad was the head coach.
Okay. All right. Are you married, Aaron?
No, sir.
Have you ever been married?
No, sir.
Were you involved in a long-term relationship?
Marnie and I were together for 18 and a half years.
How did you meet?
We worked together at Meyer and Beaver Creek when we were both in college.
Both in college?
Yes.
And that was in Beaver Creek?
Yes.
So I'm assuming that was 18 plus years ago?
Yes. I was about 19 years old.
Were the two of you living together at that point in time?
No, we didn't move in together until after Naomi was born.
So that would have been in 2005?
Approximately.
Okay. When you first established a residence together, where was that?
It was in Fairborn in a house that I'd rented for us.
Okay. You didn't stay in Fairborn, though, did you?
No.
Okay. Where else have you lived together as a family?
We moved to Leesburg and 100 Elm Street, and we stayed there until I was able to acquire the house in Highland.
The Leesburg address, that apartment, can you describe what kind of housing or was this?
It wasn't the best place to live. It was low-income housing, paper-thin walls. You know, you hear everything your neighbor's doing. They hear everything you're doing. Maintenance was not well kept, but it was right after the recession in 2008, and I was doing odd jobs and trying to work my way through college. And then when Naomi was born, I wasn't able to finish college because financially I couldn't do it. So Marnie had lost her job. I couldn't find work, and that's how we ended up in the low-income housing.
Okay. And there were multiple apartment units. Is that correct?
Yes, several.
What was your apartment like? Can you describe how the physical layout?
It was a townhouse style. It had a kitchen, living room, and then stairs on one wall that went up to a small bedroom, a small bathroom, and a medium-sized bedroom.
Okay. And you lived there until roughly June of 2013?
June of 2013, yes.
That's when you moved to the Church Street address in Highland?
Yes, sir.
Okay. Now, that's a house, correct?
It's a 4-bedroom house, sir.
Okay. Could you describe the layout of that house?
There's a living room when you first come in, and to the left there's a large living room. And if you walk straight in the front door, there's a large kitchen with an eat-in dining room. To the left of that is my bedroom. And then my bedroom has 2 doors. It has a sliding door to the kitchen, and it has a swinging door to the front living room. And then on the back of the kitchen, there's a laundry room and a bathroom. It's a 1-bathroom house.
Okay. No bathroom upstairs then?
No bathroom upstairs. Upstairs is just 3 fairly good-sized bedrooms.
Okay. Now, you have 2 children, correct?
Yes, sir.
Maxine is your younger child. How old is she?
She's 13 years old.
And Naomi is 17.
17, yeah.
All right. You think your kids are alike?
Not very much, no. They're both very smart, but Maxine is more introverted and Naomi is more extroverted.
Okay. What about like athletic-wise, things like that?
They're both athletic, but in different ways.
Okay. Now, when you say introverted, extroverted, what's that mean to you?
Maxine doesn't have any problem doing things on her own or with one other friend. But Naomi, being extroverted, she likes to be in big groups, and she needs to be around more people.
Now, obviously you were involved with Maxine when you were coaching her soccer. Have you had occasions to be involved with Naomi in the child rearing process?
I mainly took her to practices. She played soccer for a season. I was at every practice for that. She played volleyball in middle school. I was at almost all of her games I was able to, other than ones that were while I was conflicted with my work. I went to her karate tournaments and supported her. I took her to all her cheerleading practices and picked her up. I was more responsible for taking my kids to practice after working all day because Marnie worked third shift, so she would still be waking up for the day when it was time for them to leave for practice. So I would just ask her to maybe get dinner ready so when all the practices were over and we were finally home that we could have dinner together.
So due to the fact that you and Marnie worked split schedules, you had to divide child rearing duties, household duties, that kind of thing.
Yes, sir.
What did you take care of around the house?
I did a lot of the things that they weren't physically or technically able to do. I maintained the yard and the house, and I maintained the vehicles so that we could get to work and be able to run the kids all over the countryside for sporting events and karate tournaments and be able to go visit family, which was a big part of our lives, was visiting, my father. Marnie's mom and dad both live in Dayton, so we were all making trips up there regularly.
So is it fair to say then that you did more of the maintenance kind of work and Marnie did more of the day-to-day housekeeping, that kind of stuff?
Yes, sir.
All right. Now, as far as the child rearing responsibilities, how did you and Marnie discipline your children?
She oversaw the school side of things. I remember one time Maxine got a B on an interim report, and she yelled at all of us for about 3 weeks about how it's my fault that Maxine got a B because I didn't make sure.
Okay, I'm going to sustain that. That's non-responsive. Answer the question, Mr. Ludwig. Go ahead.
Okay.
All right, I'll rephrase.
What I mean is answer the questions that are asked and don't go off on tangents.
Okay.
Go ahead.
Marnie was then more involved with the education school purposes.
And taking them to the doctors.
Taking them to the doctor.
Because she was home during the days.
Did the two of you talk together or, discipline your children together?
Yes. She would say things for small things, but when a larger issue arises, we would talk about it, and we would both discipline them. We would talk about what the terms of the discipline would be.
Okay. Now, there's been some testimony or some talk while we've been here today, yesterday, about that you never allowed Naomi to have a boyfriend. Is that true?
That is something that Marnie and I both discussed. She was not allowed to have a boyfriend when she was in school. She went to an all-girls Catholic school in the Philippines.
When you say she,
Marnie went to an all-girls Catholic school in the Philippines. And that's what she was alluding to yesterday, that she didn't go to homecomings because her school didn't have that. I agreed that she didn't need to be in a relationship because she needed to focus on school and her extracurriculars, cheerleading. She was cross country. She wanted to do volleyball, but she gave that up. And karate, she was teaching karate 2 nights a week. She's got volleyball or cheerleading on 2 to 3 nights a week. It just didn't leave a lot of time. I wanted to make sure she had time for family and time to focus on school.
Did you ever threaten her or ground her over her cross-country performance?
I did after her second season because I would pick her up from her practices and there would be a group finished already. I know they all start at the same time, and she'd be jogging with her friends, talking at practice, and then her first season kind of set the bar for her times. In the second season, she was significantly slower, and I told her, I felt like, I talked to her, and I said, I feel like you're slacking. I would like to see you try and do better. After about the third or fourth meet of her times getting worse and worse and worse, I felt like she was not putting in the effort, and I did take her phone.
What would be the typical form of punishment or that you would do to Naomi?
I would give her extra chores and take her phone, because I don't spank my kids. You can count on one hand the number of times I've spanked both my kids in the last 16 and a half, 17 years.
Now, there was some testimony yesterday about a sleepover that Naomi had at your house, and several girls were there.
Correct.
Do you recall that sleepover?
Yes, I do.
What's your recollection of that event?
It was around the 4th of July. The RSD where Marnie works shuts down for a week on the 4th of July and a week at Christmas, New Year's for housekeeping. Marnie came to me and told me that they wanted to have a sleepover, they being Marnie, or Naomi and a couple of her friends, and Maxine and a couple of her friends. And I said, it was a work night. It was a weeknight. I had to work. They were off school, and she was off work. I said, you guys can do it, but you have to go to bed early because I can't be up all night. And the result of that was at like almost midnight, I went upstairs and I pulled Naomi out into the hallway. I called her out in the hallway and I said, Naomi, you guys need to go to sleep. I said, I've got to be at work in the morning. The result of that was I was late for work, and I told her that it's not going to happen again.
Was Marnie present during this sleepover?
Yes, she was. I asked her to go upstairs and ask them to quiet down, and she refused to do it, so I had to get up out of bed and go upstairs and request that they quiet. And I also told the other children, I said, guys, I've got to sleep. Can you please go to sleep? Because they were, there was a steady stream of kids going to the bathroom, turning the lights on, walking through the kitchen, which was right next to my bedroom.
And there was some talk about a birthday party that Naomi had at your residence.
Yes.
Do you recall that?
Yes, it was her 10th birthday because that's when we had the swimming pool. There were a lot of people at that birthday party. My father and my uncle and I sat under a shade tree. Marnie's dad came down from Dayton. I showed him around the house because he hadn't been there in almost a year. I wheeled my grandmother down from her house because that's one of the reasons I bought the house in Highland, was because my grandmother lived up the street. And I wanted to be close to her in the last years.
So this was for Naomi's 10th birthday.
Yes, we had a swimming pool, and Marnie went and bought a slip and slide, and the kids were playing on one side, on that side of the yard. The adults were sitting under the shade tree and lawn chairs. It was a lot of people there. It was a large party. At one point, the kids had gone in the house, and I went inside to ask them to come back outside because that's where the party was. I didn't want the house getting torn up and being a mess being made.
These were 10-year-old kids. These weren't teenagers, 10 and younger, correct?
Right. Yes, sir.
Now, did you ever have an occasion to chaperone any dances at school, at Naomi's school?
I was voluntold by Marnie that I had to chaperone these dances. She told me that all the cheerleaders' parents have to help do it. We had to do things like work the concession stands at the high school during games to help fundraise for them. I didn't want to go, but Marnie told me that she wanted me to go, and I went.
How many of them did you actually chaperone?
I believe 3. Her freshman year, the first one I went to, I talked to a couple of parents. We asked if they needed help at the concession stand food area, and they said no, they had it under control. If we could just
Objection to what people said.
I'm going to sustain that. It's not really responsible.
Okay. So you chaperoned other dances.
right, and a janitor told me to watch the back hallway.
Objection again.
Well, I'll sustain as to what you were told.
Okay.
Okay,
When you were chaperoning those dances, was that just you, or was Marnie also chaperoning?
Marnie and I stayed together, except when I went outside to smoke.
All right. Do you recall an incident sometime in late 2020, receiving a call at work about Naomi disappearance?
Yes, it was around the end of November. Marnie called me distraught.
Objection to what Marnie said. This is hearsay.
Well, I'm going to overrule it. It's not admitted for the truth of it, just to explain what the defendant did. So, but limit it as much as possible.
Okay. Marnie called me distraught. I asked her what was wrong. She told me that she asked me if I knew where Naomi was. I said I did not. I said, can you call my dad and see if she went to his house, because she has not contacted me. So that was around almost 10:30, 11 o'clock. Around 12:30, I called her back. Naomi had still not called. Marnie, I believe, had a tracking app on her phone so she could follow where she was at. Her phone was turned off, so she couldn't be tracked. And I started to become concerned, and I went to my supervisor and told her that I would be leaving if I haven't heard anything by 1 o'clock. At 12:55, I believe it was, I get a phone call saying Naomi's home. She said she went to Walmart for 3 hours.
And that was in late November of 2020?
Yes, sir.
Okay. Now, late December of 2020, early January 2021, did you take a vacation?
Yes, sir. I went to Rio de Janeiro, Brazil.
Okay. What was your reasoning, I guess, for going to Rio de Janeiro?
I'd heard that it's a good place to go for New Year's. They have one of the biggest fireworks displays in the world. I'd always wanted to see Christ the Redeemer. It's just a beautiful place. It was amazing. I lived in Florida north of Miami for 10 years, so for some place to seem exotic to me and beautiful, it has to be pretty beautiful and exotic, because I grew up 3 or 4 miles from the beach. So.
But you went by yourself.
Yes, sir.
Why?
My friends like to do their own things on vacation. One of my best friends likes to go to Colorado skiing. Most of my other friends don't have the financial means or the time, or they have families. So just Marnie never has enough PTO because she misses a lot of work to be able to accommodate things for the family. I get a lot of PTO because our sick days, our vacation time, and everything is rolled into just basic hours. I don't miss a lot of work. I try and save it all for vacations, because we've always taken family vacations, and I was able to save enough over the years to be able to take a week here and there to go places.
Do you work a lot of overtime at work?
Yes, a lot.
And as a result of that, you get vacation time or PTO time, as you said.
I accrue it faster, much faster, yes.
And this trip was one of the ways that you used it.
Yes, sir.
When you came back, how long were you there?
I was there for approximately 7 days, and it was 26 hours from the time I left my hotel room until I arrived home, so you lose a day traveling each way.
How were things at home when you returned?
The kids were excited to see me. The dog was super excited to see me. Marnie, not so much. She didn't even get out of bed to greet me when I got home. And after I gave the kids their gifts, spent some time with the dog to get him to calm down, I went in and I said, gave Marnie a hug and gave her a gift. And then she just kind of glared at me. And I walked across the room and I bought her a beach towel or something. And she threw it at me across the room and said, go put it somewhere. I don't care.
Were you upset about that?
I was hurt. I wasn't angry. I was hurt.
Now, on January the 20th, that was Marnie's birthday, correct?
Yes, sir.
Do you remember her birthday?
Yes, sir.
What do you remember about that day?
I worked 5 to 5, 5 a.m. to 5 p.m. I got home. She was still in bed. The kids were in their rooms. I went in and talked to her to see what she wanted to do. I wanted to take her out for dinner. She said she didn't feel like it. We were talking. I said, well, maybe we can go out this weekend. And then I went in my closet and I got a gift I bought her. I bought her a Dooney and Burke purse and I gave it to her. She kind of looked at it and she just set it on the floor next to the bed. And I left and I went and talked to Maxine for a while. I didn't even know if Naomi was home or not. And I asked Maxine, I said, do you want to go get your mom something for dinner? And then her mom said she wasn't hungry. They had a late lunch. So that's why she was still asleep when I got home at 5 o'clock. And she proceeds to get up, get ready for work, and then she comes. I would lay down for bed about 9:15 because I had to be at work at 5 a.m. the next day. She proceeds to come in the bedroom. Both the kids were upstairs, and she climbs on top of me and says that she said she wanted sex.
Objection. Hearsay. None of this was testified to yesterday.
Yeah, I'll sustain that. George, disregard that.
Did
Ask
the two-
another question.
Did the two of you get into a disagreement or an argument?
Yes, because I was not want to be romantic, she started questioning me as to what was going on. She pressed me on the issue. She called off work. She was very upset. I told her, it's your birthday. I said, I don't want to get into it on your birthday. Let's just relax, okay? Nothing's changing. Nothing's going on. And after about an hour of her being upset, yelling at me, telling me I need to tell her, I finally broke down and told her that I was talking to someone. I wasn't sure where it was going. I didn't know what was going to happen, but as far as I was concerned, nothing is going to change with our lives. Because at this point, this lady was just a friend. And I didn't know what to do. She's got 3 children and lives in Brazil. I've got a career. There's no work in my line of work in Brazil that my license will allow me to do. I told Marnie, I said, she kept saying, you're going to kick me out. You're going to kick me out. I said, no. I said, I'm sticking to my plan, which my plan was, after Naomi graduated high school, I wanted to go contract overseas in the Middle East because that's where the best money is to be made. I could make 6 figures there. So, I've got 1 kid going into high school and 1 kid going into college. I wanted to be able to pay for Naomi's college and prepare to pay for Maxine's college and hopefully pay the house off at the same time. I had goals I was trying to achieve, and that was the only way I saw that it was feasible.
Did you do or say anything that would have led Marnie to believe you were kicking her out of the house?
To the opposite. I told her that if it was that big of a problem, I would leave, and her and the kids could stay at the house. And I told her, I said, you guys can stay here as long as you want. She said, well, what about if I want to date another man? What if I want a boyfriend? I said, have a boyfriend, but he's not living in my house. I said, have respect for my home.
Aaron, at any time, did you ever place your penis in Naomi's mouth?
No, sir, absolutely not.
At any time, did you ever place your penis in Naomi's vagina?
No, sir, absolutely not.
At any time, did you ever place your penis in Naomi's rectum?
No, sir, absolutely not.
At any time, did you ever have Naomi masturbate you?
No, sir, absolutely not.
How do these allegations make you feel?
They make me feel sick to my stomach, heartbroken, and betrayed by the people that I love the most.
I don't have anything further at this time, Your Honor.
Cross.
Let's start with Rio de Janeiro. You talked about how gorgeous it is, and you wanted to spend New Year's there, and a lot of your friends, aren't able to do that because they have families. Well, you have a family also, correct?
Yes, ma'am.
And don't you think that your daughters and Naomi or Marnie, for all intents and purposes, is his wife? I mean, you two have been together for 18 years, correct?
Yes, ma'am.
Okay. Don't you think they would have enjoyed that? Yes or no? Would they have enjoyed that?
Yes, ma'am.
Okay. Didn't you go and you say, now and then I did this, I just needed a break, correct?
Yes, ma'am.
But didn't you just go to Brazil in October?
For Halloween, yes.
In 2020?
Yes.
So you go in October, come back for a month, you go again in December. So this is more than just, I need a break every couple years. You have to talk, yes?
I had a trip planned to go to Southeast Asia in March of 2020.
Mm-hmm.
It was canceled because of COVID. I had a ton of PTO saved up for that trip. I didn't get to go. The only place I could go was Brazil or Mexico. I did not care to go to Mexico. So I went in October. I had fun. I decided I would go back for New Year's, a week each time.
Okay. But, so right back to my original point, you had fun, you had, couldn't go where you wanted in March, so then you had to go to Brazil in October. And again, you have two daughters and basically a wife at home, and they would have enjoyed that, wouldn't they have? Yes?
Yes,
Okay.
of course.
What about Thailand? When did you go to Thailand?
I went to Thailand in September, October of 2018.
2018 or 2019?
2018.
And isn't it true that Marnie asked you to go to these different places?
Yes.
She wanted to go with you, didn't she?
Yes.
Okay. And you wouldn't allow her to go?
She didn't have...
You wouldn't allow her to
She
go?
didn't have time off work. She couldn't afford it. I didn't want to pay. I couldn't afford to pay both of our ways.
Mr. Ludwig, with all due respect, you give up that stuff for yourself when you have a family, correct?
Object.
Overruled.
I took the family on vacation. We took the family on vacations almost every year.
Okay, where'd you go I know you went to the Philippines.
2019, I paid for most of the trip to the Philippines. I bought plane tickets for everyone, except her father. I paid for all the accommodations. Her father, through her grandmother, paid for the food.
No, I don't want to keep beating a dead horse, but Mr. Ludwig, it's your family, correct?
Yeah, I understand.
So it's not a great... You've not done a great thing by paying for them. That's your duty, correct?
Marianella didn't contribute. That's what I'm saying.
Okay.
We were going to see her family, and I paid for it. That's what I'm saying.
It's a great thing you did. You resigned from Village Council in 2021 in January, correct?
As soon as I got out of jail for this.
You resigned
Yes.
because you were charged with a felony?
Because I wanted to save the village the embarrassment. You can serve on council being charged, but
Who'd you get to fix that fire truck you were so proud of?
a coworker of mine that's confined space trained.
Okay. Okay. So somebody that you have, someone that's a friend of yours?
Yes.
You had a friend of yours fix a vehicle that belongs to a public entity?
Yes.
Okay. When's Naomi's birthday?
June 16th, 2004.
2004? Are you sure?
Pretty sure.
Pretty sure? You're pretty sure that your first daughter's birthday is in 2004? So when did you move? So when did you move to the apartment in Leesburg?
I don't recall.
Okay.
It was 2000. I think it was late in 2006.
How old was Naomi when you moved?
She was around 2 years old.
Let's talk about that sleepover. The one when the girls got in trouble for being up too late. Do you know what one I'm talking about?
Yes.
Okay. How old were the girls that were staying at your house?
They would have been around 11 or 12 and 7 and 8,
Okay.
6, 7. Because Maxine had friends there as well.
Mm-hmm. And Mr. Ludwig, so what year was this?
It was I'm not sure. It would have been 2014 or 15.
Okay. So let's say it was let's say Naomi was 10, just for the sake of argument. Can we agree to that?
Okay.
Okay. So, and you have how many 10-year-old little girls there?
I believe Naomi had 2 friends and Maxine had 1 friend.
Okay, so you've got 5 little girls.
Correct.
And you've had little girls in your life at least 10 years, right?
Yes.
And would you agree with me that there is no population that uses the restroom more than a little girl?
That's a fact.
Okay, so it shouldn't have been a surprise to you that these little girls were running down the stairs to the bathroom, correct?
I understand that,
Okay.
but it was almost midnight.
Right.
So they were still up. That,
And- Right, but little girls pee in the middle of the night, correct?
I could hear
Okay.
them. They were awake. They all slept in the same room.
Right. And you testified that you pulled her out into the hallway.
Yes, I called her out in the hallway.
No, that's not what you testified to. You changed it to that, but initially you said you pulled her out into the hallway, which is exactly what Hallie testified to, isn't it?
Yes.
Okay. And then you were talking about working the concession stand and being a chaperone, and it's a lot of stuff, isn't it?
Yes.
I mean, you got to take these kids to ball practice and soccer practice and cross-country practice and pick them up and take them to meets, and it's a lot.
It's part of being a parent.
That's exactly right, which is why I was going to ask you, why are you complaining about it?
I wasn't complaining. I was just stating a fact.
Now, let's talk about, you came back from Brazil and you gave Marnie a beach towel, and your feelings are hurt because of how she acted. Correct?
Her reaction, yes.
Okay. But isn't it true that you had met another woman in Brazil?
Yes.
Okay, so it's a little far-fetched to think your feelings are hurt because she doesn't react the way you think she should. You're talking to another woman, correct?
Well, she also didn't greet me when I came home. We hadn't been on the best terms for several months.
And she should have been at the door ready for you, correct?
No, but she could have gotten out of bed to give me a hug.
She works third shift, doesn't she?
I didn't get home till late in the afternoon.
Does she work third shift?
Yes.
Okay. And that's your house, correct?
It's my family's house.
That's not, I mean, you testify that it's your house.
I own it.
You told her you'll have respect for my house and not bring another person into it, correct?
Absolutely.
Okay. At your house. That trip to Brazil in 2020, was that the first time that you met other women?
Romantically, yes.
So you didn't have, you didn't have occasion to have pictures with other women and doing other things?
I did. I partied.
Okay. You told Marnie that she was too fat for you, didn't you?
We both joined the gym.
That's not what I asked you. I'm sorry. I asked you, did you tell Marnie, you told Marnie she was too fat for you, didn't you?
I told Marnie we both need to get in better shape because we both have medical issues and it's both related to our weights.
So the answer is yes.
I never said you're too fat for me.
Okay.
No.
And you told Marnie, you're the man of the house, you get what you want, didn't you?
No.
You never said that.
No.
Naomi started her period when she was 14, is that correct?
I believe so. It's not something a father likes to hear about or think about.
You have little girls, right?
Yes.
So it's something that comes with little girls.
I accept that. That's
Okay.
fine. But
So she started her period when she was 14, isn't that correct?
if that's what you're saying, I don't remember.
Okay. And you insisted that Marnie put her on birth control, didn't you?
No.
You never did that.
No.
So Marnie and Naomi are both liars.
In that instant, yes.
Okay. So your daughter's a liar. Is that what you're saying?
Well, she's making these allegations, and I'm saying that it absolutely did not happen. So
So you're calling your daughter a liar.
she lied to me about where she was the day she said she went to Walmart.
I'm glad you brought that up. Mr. Ludwig, Naomi is how old?
She was 16 when she told me that.
Okay. So she's 17 now, right?
Yes.
And she snuck off and was missing for 1 to 3 hours, is that correct?
She lied to her parents.
Mr. Ludwig, I'm sorry that this is confusing. I'm trying to make it simple, yes, no answers. Is it correct that she was missing for 1 to 3 hours?
Yes.
Okay. And Mr. Ludwig, were you a teenager?
Yes.
And did you ever sneak out of the house? Did you ever go someplace without permission?
Overruled.
Yes or no?
I told my parents when I was going and where I was going.
But did you have more freedom than Naomi does?
Not a great deal.
Okay. Then let's do this. Mr. Ludwig, do you think that a teenager lying one time about where she is in high school makes her a liar forever?
She had.
Yes or no?
Yes.
Okay. You didn't allow Naomi to have a boyfriend, did you?
Marnie agreed with it.
Again, yes or no? Did you allow Naomi to have a boyfriend?
Objection, Your Honor, has been asked and answered.
Overruled.
No, her mother and I did not allow it.
Okay. And Naomi didn't have a job when she was 14, is that correct?
Excuse me?
Naomi did not have a job when she was 14, correct?
That is incorrect.
Okay, where'd she work?
She went with her grandfather to crystal shows and helped
Okay.
with crystal shows. She gets paid to teach karate.
Okay. And Naomi didn't go to dances until high school, correct?
She went to a middle school dance.
Okay. And when Naomi was 14, you were the only person having sex with her, correct?
No.
Okay. You had a blue recliner in the living room at the apartment in Leesburg, correct?
Yes.
Okay. Naomi testified you lived in 2 homes in Highland County, is that correct?
Yes.
Naomi testified that she was 6 when you called her to the blue recliner in the living room, correct?
She testified that, yes.
Okay. And she testified you put your fingers in her vagina in the blue chair, correct?
She testified that.
And you had a gray TV in your bedroom, didn't you?
There might have been. I don't recall.
Don't remember the TV.
No.
Marnie and Naomi both remember that TV.
I slept in the living room. I didn't spend a lot of time in the bedroom.
Okay. And Naomi testified she was 7 when you put your penis in her vagina in that bedroom, correct?
That's what she testified.
And you like to have anal sex, isn't that correct?
Objection.
Rule.
May we approach?
All right. Objection's overruled. You are to answer the question.
Do you need me to repeat it?
Yes, please.
And you like anal sex, isn't that correct?
From time to time, yes.
And you complained to Marnie because she wouldn't do that kind of thing with you, didn't you?
I wouldn't say complained. I asked her to a few times.
Naomi testified you put your penis in her anus, didn't she?
She did testify that.
And you promised her you'd only put the tip in. Isn't that what you told her?
That's not what I never said that. That's what she testified.
And you took her, Naomi testified you took her to the corner in the bedroom and made her kneel. Remember that?
She testified that.
You put your penis into her mouth at that point. She testified to that?
She testified to that.
But you're calling your daughter a liar. Is that correct?
Yes.
And all of her friends are liars. Is that correct?
She might have made a statement. I wasn't there. I don't know. I can't speak to it. No one ever said anything to myself or Marinella about it, or my father, Naomi's grandfather, who's at all these sporting events where these parents are.
You talked to your dad about this?
Yes.
And one moment, Your Honor. Nothing further.
Redirect.
Aaron, did you ever have any type of sexual relations with Naomi?
No, sir.
Nothing further, Judge.
All right, you may step down. Next witness.
Defense with rest, Your Honor.
All right, defense rests. Is there going to be any rebuttal?
Nothing further.
No rebuttal? All right. Counsel, approach, please. All right, ladies and gentlemen of the jury, that's the evidence. And it will now, the court will instruct you on the law. I did neglect this morning to remind you to turn off your cell phone, so if you haven't done so, please do so at this time. Now, ladies and gentlemen, you've heard the evidence. It's now the duty of the court to instruct you as to the matters of law. Court and jury have separate functions. You decide the disputed facts. The court provides the instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept these instructions and to apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. An indictment informs the defendant that he or she has been charged with an offense. The fact that it has been filed may not be considered for any other purpose. A plea of not guilty is a denial of the charge and puts in issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of any one or more of the offenses that have been charged in the indictment. Now, reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. It is a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You'll apply the tests of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand and their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding the testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. You're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. And during cross-examination of witnesses, counsel was able to inquire into some matters that did not directly relate to issues before the court. Such questions and answers are permitted for the purpose of helping you to determine the credibility and the weight to be given to the testimony and for no other purpose. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to you to help you arrive at a just verdict. However, as with the other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining this weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of the case, and the usual rules for testing credibility and determining the weight to be given to testimony. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and the exhibits that the court has admitted into evidence during the trial. Now, evidence may be direct, or it may be circumstantial, or it may be both. Direct evidence is testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, exhibits admitted into evidence during that trial. Now, circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. To infer and to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. Now, when considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. In other words, you cannot stack one inference upon another inference to reach a factual conclusion. So, what does that mean? Well, let me give you an example. You have two children, and you have a cookie jar in the kitchen, and you come into the kitchen, and you see crumbs are all over the counter. Well, you can make an inference that, well, your kids have gotten in the cookie jar. But from that fact alone, you cannot infer which one did, because you only have one fact to make an inference from. Now, if you go into the room of one child and that child has crumbs on the floor and the other one does not, then that's a second inference. Then you can make the inference that it was that particular child. So that's what I mean by not stacking one inference upon another inference. Now, if circumstances create inferences that are consistent with either acquittal or guilt, then the defendant must be acquitted unless inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilty if the circumstances are entirely consistent with defendant's guilt, are wholly inconsistent with any reasonable theory that he is not guilty, and are so convincing as to exclude a reasonable doubt of guilt. When the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that defendant is guilty. Now, the evidence does not include the indictment, the opening statements, or closing arguments of counsel that you will hear later on. Opening statements and closing arguments, as I've indicated to you previously, are designed to assist you, but they are not evidence. Now, any statements that have been stricken by the court, and there were several, that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might have been included in a question that was asked but not answered. Now, there were a number of exhibits introduced, and testimony relating to them has been introduced, submitted into evidence. And you may consider whether those exhibits are the same objects and same conditions they were originally. You'll determine what weight, if any, each exhibit should receive in light of all of the evidence. Now, the first four counts of the indictment are all under the same statute, and so the instructions I'm going to give you on that will all be considered together. Now, the law under which the defendant is charged in counts 1, 2, 3, and 4 is entitled rape and is numbered Ohio Revised Code 2907.02A1B. This law states in pertinent part as follows: no person shall engage in sexual conduct with another who is not the spouse of the offender when the other person is less than 13 years of age, whether or not the offender knows the age of the other person. So before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the period of June 1, 2010, continuing through December 31, 2010 as to count 1, on or about the period of January 1, 2011, continuing through December 31, 2011 as to count 2, on or about the period of January 1, 2012, continuing through December 31, 2012 as to count 3, and on or about the period of August 1, 2013, continuing through June 1, 2014 as to count 4. In Highland County, the defendant engaged in sexual conduct with another, NL, who was not the spouse of the defendant, who was less than 13 years of age, whether or not the defendant knew the age of NL. So the essential elements of rape as charged in counts 1 through 4 are as follows: that the defendant did 1, engage in sexual conduct with another, NL, who was not his spouse; 2, that the other person, NL, was less than 13 years of age or older, whether or not the defendant knew the age of such person; and 3, that it occurred in Highland County, Ohio, on or about the date alleged in the indictment. Now, it's not necessary the state prove the offense was committed on exact date as charged in the indictment. It's sufficient to prove it took place on a date reasonably near the date claimed. Before you can decide whether the state has proved beyond a reasonable doubt all of the essential elements of the offense charged with which the defendant is charged in the first 4 counts, you must first decide whether this is the correct county in which this trial should be held. The court must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. And that's what's known as venue. Now, sexual conduct means vaginal intercourse between a male and a female, anal intercourse, fellatio, cunnilingus between persons regardless of sex without privilege to do so. Now, the insertion, however slight, of any part of the body, an instrument, apparatus, or object, into the vaginal or anal cavity of another. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. Now, anal intercourse means penetration of the penis into the anal opening of a man or woman. Fellatio means a sexual act committed with penis and the mouth. Cunnilingus means a sexual act committed with the mouth and the female sex organ. Spouse means a person married to an offender at the time of an alleged offense. Now, the prosecution is not required to prove that the victim physically resisted the defendant. If you find the state proved beyond reasonable doubt all of the essential elements of the offense of rape as set forth under counts 1, 2, 3, or 4 of the indictment, according to your findings, your verdict must be guilty as to that count. If you find the defendant failed to prove beyond reasonable doubt any one of the essential elements of the offense of rape as set forth under counts 1, 2, 3, or 4 of the indictment, according to your findings, your verdict must be not guilty as to that count. Now, if your verdict is guilty on any one or more of counts 1 through 4, then you will separately decide beyond a reasonable doubt whether NL was also less than 10 years of age at the time of that offense. If your verdict is not guilty of any one or more of counts 1 through 4, you'll not consider that issue as to that count. Now, the law under count 5, in which the defendant is charged, is also entitled rape, and is numbered Ohio Revised Code 290702A2. This law states in pertinent part as follows: no person shall engage in sexual conduct with another when the offender purposely compels the other person to submit by force or threat of force. Now, the defendant is charged with rape under that section. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the period of January 1, 2018, continuing through December 31, 2018, and in Highland County, Ohio, the defendant engaged in sexual conduct with NL, and the defendant purposely compelled NL to submit by force or threat of force. So the essential elements of the crime of rape, as set forth in count 5, are as follows: that the defendant did 1, engage in sexual conduct with NL who was not his spouse; 2, the defendant purposely compelled NL to submit by force or threat of force; and 3, the offense occurred in Highland County, Ohio, on or about the date alleged in the indictment. Now, most of the, I think almost all of the definitions in count 1 apply to 1 through 4 apply to count 5, so I'm not going to repeat them. But the instructions about the time of the allegation, the venue, sexual conduct, and all of those definitions, and then spouse, all apply. Now, purpose to compel is an essential element of the offense of the crime of rape. A person acts purposely when it is the specific intention to cause a certain result. It must be established in this case that at the time in question there was present in the mind of the defendant a specific intention to compel NL to submit to sexual conduct by force or threat of force, and this is under count 5. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing on purpose. Where an act is a crime, a good motive or purpose is not a defense. Now, force means any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. Threat includes a direct and indirect threat. And resistance, the same as in the other counts, is prosecution is not required to prove the victim physically resisted the defendant. Now, if you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of rape is set forth under count 5 of the indictment, according to your findings, your verdict must be guilty as to that count. If you find that the defendant failed to prove beyond a reasonable doubt any one of the essential elements of the offense of rape as set forth under count 5 of the indictment, according to your findings, your verdict must be not guilty as to that count. So if you find the state proved beyond a reasonable doubt all the essential elements of any one or more of the offenses charged in the separate counts in the indictment, your verdict must be guilty as to such offense or offenses according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of any one or more of the offenses charged in separate counts in the indictment, your verdict must be not guilty as to such offense or offenses according to your findings. Now, the charges set forth in each count of the indictment constitute a separate and distinct matter. You must consider each count and the the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or more of the offenses charged in the indictment. All right, now that concludes the court's instructions on the substantive law regarding the offenses charged in the indictment. And those will be the definitions you'll apply in your deliberations. Now, just to put your mind at ease, we'll be giving you a copy of these instructions to refer to in your deliberations, and particularly it'll have the dates on the counts if you need to refer to that under counts 1 through 4, where there are different dates. It's 10, 11, 12, and then I think 13 to 14 in count 4. But that'll help you identify which verdict form to fill out for each one, and I'll explain that to you after we hear closing arguments. So it's now almost 9:39. We started at 8:30, a little after 8:30, 8:31 or so. So I'm going to go ahead and take a 10-minute break now, and then when we come back, the attorneys will present their closing arguments. I will then instruct you on how to deliberate and return verdicts, and then you will deliberate. And the deliberations will take place here in the courtroom. Again, because of COVID, we're not putting everybody in the small jury room, so everyone will vacate the courtroom, and you'll use the courtroom. Now, when you do deliberate, you will not be permitted to have your cell phones or any iPads or electronic devices whereby you could communicate outside to the outside world, so to speak. So you can either leave those in a vehicle, or if you live close, take them home, or the bailiff collects those, puts them in different bags, and then holds them for you and returns them to you after the case is completed. So I just want to tell you that so you know for that. Now, during the break, you may contact other persons to let them know where your schedule is or what you think the schedule might be. But again, don't talk to them about it. Don't make any comments about it. You're still not to make any conclusions, draw any make any kind of a decision because again, you haven't heard everything you need to make that decision yet. We still need to hear closing arguments and then the final instructions from the court. Don't discuss the matter or talk with any of the parties that are involved. Don't allow anyone else to talk to you about it. Don't look up anything about it on the internet or read or listen to anything that might be on the radio or podcast or anything of that nature. All right, so it's now 9:40, so come back at about 9:50 or a minute or two after that as soon as you can. Thank you.
Please rise.
All right, we're back on record. Remind everybody again to turn off your cell phones and other electronic devices. We will now hear the closing arguments from the attorneys. Now, again, I'll instruct you that these arguments are not evidence. They are simply the attorneys' claims as to what they believe that the evidence has shown and how the law applies to that evidence. The state has the burden of proof in the case, and so they present on two arguments, an opening portion, and then after the defense presents its closing, then the state can make the final. So that will be the procedure we'll follow. At this time, Ms. Collins, on behalf of the state.
Thank you, Judge.
As the judge said, I had two opportunities to talk to you this morning in closing, so I'm going to keep that first one short and to the point. May it please the court, Mr. Rain, and obviously ladies and gentlemen of the jury, I first want to thank you for your time and attention to this matter. I know that this is obviously a very serious matter. I know that this is not easy to listen to. I know that this is not testimony that anyone is comfortable with. But we are one
All right. Hold on, Ms. Collins. The battery is apparently dead in the microphone, so the bailiff's going to replace that. According to the computer, it's not working. All right, thank you. You may continue.
Okay. We are one of the only countries that use a jury system to decide guilt in cases, and that only works because of people like yourselves who take your service seriously, and for that I want to thank you. I told you yesterday that the state would prove with evidence and testimony that the defendant, Aaron Ludwig, began raping his daughter when she was 6 years old and in the first grade, and those rapes and sexual assaults continued until she was 14 years old. And the state has proven exactly what we set out to prove. Beginning when Naomi was just 6, the defendant began using her to fulfill his sexual needs. He called her to the blue chair in the living room, where he penetrated her vagina with his fingers. He called her to his bedroom to hang out, where he penetrated her vaginally and yelled at her for crying in pain. And so she just stared quietly at the television. He raped her anally, promising only to put the tip in. And where she realized this meant the rape wouldn't last as long, he ordered her to the corner of the bedroom, where he ordered her to perform oral sex on him, staying in the corner so they wouldn't be seen by Max. And then he ordered her back to the bed, where he ordered her to masturbate him with her hand, while he called her his good girl. He raped her on the couch in the living room after she started her period, while she focused on the K-pop song playing in the background. Naomi didn't just make this story up to get back at her cheating father. She started talking about the things she did with her father when she was only 9 years old and in the 4th grade. She talked about laying naked with her father until white stuff came out. She started humping her friend and touching her at a sleepover because that is what she had been programmed to do at night with her father. She did things and talked about things well above her age, things that she shouldn't have known about, things that her friends did not understand. You have heard the story of the nightmare that Naomi lived from her own mouth. You have heard from other people that she told about the abuse. You have heard from the expert in child abuse who interviewed Naomi about the sexual assaults. And finally, you have heard from Detective Antonor, who has investigated hundreds of child sexual assault cases. And all of these people have said the same thing. Ladies and gentlemen, you have the testimony and you have the evidence and you have a job. Find this man guilty of the nightmare that was little Naomi's life. Thank you.
All right, thank you, Mr. Ring. On behalf of the defendant.
May it please the court. Ms. Collins, Mr. King, ladies and gentlemen. The state is asking you to do one thing right now. They're asking you to do one thing. They're asking you to calmly and unequivocally believe that if you say something over and over and over, if you say it louder, that it's true, that it must be true. Well, the one thing that I want to say to you, that one thing that I want to make sure that you think about and make sure that you understand is a number. 800. You may ask, what's 800 mean? What does that mean? That's how many times Naomi alleges that during an 8-year period she was sexually assaulted by her father. 800 times. Now, this is not a young girl. This is not a toddler. This is a 17-year-old girl. One who knows numbers, who knows the meaning of things. I mean, there's been evidence to show that she's not only a good student, she's an excellent student. She goes to college. She's going to she already graduated high school. She's got a 28 on her ACT. She participates in the Talented and Gifted program. She's clearly intelligent. She knows what she's saying when she said this happened 800 times. But yet, what physical evidence has the state given you in these last 2 days to show it? The answer is simple. Absolutely none. Naomi was examined at the Marison Center. She underwent a physical examination. You're going to have an opportunity to review the report. You're going to get a chance to look at it. And you're going to see that there is nothing to support her allegations. Absolutely nothing. 800 times. 800 times. Absolutely nothing to support it. Not only in those 800 times, she's not alleging that in these 800 times that this happened, that he is taking her away, he's hiding her someplace. This is happening, alleged to have happened in their home with another child in the home. This is not the two of them home alone. Another child is in the home. I have 2 daughters. I'm sure many of you
Objection.
Cannot make it personal.
I'm sure that many of you have children of your own. 800 times this happened. I think there was testimony at one time maybe Maxine came in a room and Naomi didn't have any clothes on and covered up. One time out of 800 potential incidents that this is supposed to have taken place. 800 times. So their theory is if you say it often enough, if you say it loud enough, if you come in here and you be aggressive, and that means that it happened. Ask yourself, 800 times, not a shred of physical evidence. When Naomi talks to the forensic interview, when she finally gets to the forensic interview, by that point in time, she's alleged to have told her boyfriend, told her boyfriend's mom, told her mom, talked to the detective, and then 2 weeks later, she's at the Marison Center for a forensic interview. She's talked about it a lot. You get an opportunity to look at that interview. You saw it. It was played in front of you. It's part of evidence. You get a chance to look at it. The state's telling you things that Aaron is alleged to have said, well, I'll just put the tip in. Did you hear that anywhere? It wasn't there. It didn't come from there. That's completely outside the scope of what came in on this trial. Said, Dad's not very nice. He yells. We hear Marnie say that he's not really a yeller. He grounds. That's his punishment. He grounds. I don't know what was going on in the Ludwig residence in early, mid-January of 2021. Only the people who lived there know what was going on. Naomi, according to the testimony of her boyfriend, was FaceTiming. She was talking to the boyfriend. She went downstairs. There had been an argument that had taken place between her mother and father. Mom was clearly distraught. She was distraught talking about it when she was in here, that she was afraid the relationship was going to be terminated. She didn't want that to happen. She was worried about where she was going to live, what was going to happen with the children. She clearly saw Mom was upset. She saw that. She goes back upstairs. Boyfriend says she's crying and immediately blurts this out. And the snowball effect occurs. 800 times in an 8-year period. Ladies and gentlemen, I implore of you, follow the instructions that you've been given. Listen to the instructions that you've been given. Follow them. At the conclusion, 800 times is going to lead you to the fact that this just doesn't make sense. It doesn't make sense. And if it doesn't make sense, you only have one option: to find Aaron not guilty. Thank you.
All right. Thank you, Mr. Ray. On behalf of the state, closing.
Let's talk about a few things Mr. Ring said. He said that Naomi testified it happened 800 times. It's actually not the testimony. She actually testified 1 to 2 times a week for the last 8 years. It was actually Mr. Ring's question that had the word 800 times in it. And what Mr. Ring's questions are just questions. They aren't evidence. It's Naomi's response that is evidence. And her answer was 1 to 2 times per week for the last 8 years. And she is a smart girl. She's genius smart. So being that smart, she were making this up, wouldn't she think, 800 times? Nobody's going to believe that. I better change my story? No, because she didn't say 800 times. Mr. Ring said 800 times. She said 1 to 2 times a week. Now, I'm not sure, maybe Mr. Ring wasn't paying very close attention to Naomi's testimony, but I actually said, I asked her about the anal sex, 2012. She had just turned 8 years old. Did he do something different then? She testified. He put it in her butt. Did you say anything? I told him it hurt. He promised to just put the tip in. How did you feel about it? Well, I hated it, but it meant that it went quicker. He ejaculated faster. She did testify that he promised to only put the tip in. She said that on the witness stand. Mr. Ring next wants to say, gosh, 800 times, has to be some sort of finding. And then he talks about the medical records and says, you're not going to find anything in there. The medical records actually say an examination, regardless, even a normal examination would be consistent with the history reported because it's 2 years later. It's not the morning after. 2 years has passed since the last time this man raped his daughter. And I'm sure that during the trial there were things that were mentioned and they weren't developed and they left questions in your mind. But be mindful of the judge's instructions. There are often legal reasons for what we are allowed to share and what we are not allowed to share. As the judge has instructed you, the evidence and testimony to be considered in this case is what you heard from that witness chair and the exhibits that were admitted into evidence. In considering the testimony and evidence, it is important to remember that nothing the defense attorney said in his questions is evidence. Only the answers from the witness chair is evidence. One of your main jobs as a jury is to weigh the credibility of the witnesses, and to do this, you apply the truthfulness that you apply in your everyday lives. You look at their appearance on the stand, their manner of testifying, their reasonableness of their testimony, their opportunity to see, hear, and know the things they are testifying about. Look at the accuracy of their memory, their frankness, their lack of frankness, their intelligence, their interest and bias in the case. Taken with all the facts and circumstances surrounding their testimony, and with all that in mind, you decide who to believe. Let's apply this to a couple of the witnesses that you've heard from. First, you heard from Naomi, the victim of these repeated rapes. She was frank during her testimony and her emotion during her testimony. This is obviously not something that is easy for her to talk about, and yet she did her very best to explain to you what she had grown up with. Her memory, one that she wishes she could erase, is very fresh. She relives these rapes. She has no bias in this case, despite the defense's allegations that she made this up because her father was cheating on her mother, or the allegations that she made this up because she wanted a boyfriend and wanted more freedom. In fact, the defendant would ask you to believe that because she was missing for an hour to 3 hours and she had a boyfriend and she didn't tell her parents, that she's the biggest liar ever. You never believe a person that sneaks off with their boyfriend for 2 hours and lies about it. They're a liar for the rest of their lives. The problem with their theory is that Naomi first talked about these rapes when she was 9 years old. 9. She's talking about white stuff when she was 9. 8 years before she had the secret boyfriend, and 8 years before she knew her dad was cheating on her mom. So to believe that Naomi is a liar and she made this up would mean that she would have to have started this lie 8 years ago when she was 9 years old. Obviously, that flies in the face of common sense. There's no benefit to Naomi to lie about these rapes. They would have you to believe that the benefit would be that the defendant wouldn't be there to tell her what to do. He was leaving anyway. He's not going to be there anyway. By disclosing the rape, she's now been repeatedly interviewed, undergone medical examinations, had to testify. Finally, Naomi told you she didn't make this up. And what child would make up this type of thing? The things she knows and the things that she remembers are beyond the imagination to make up. Next, you heard from Marnie, Naomi's mom. Again, open with her life, answered questions that certainly were embarrassing and uncomfortable. But she was in the best position to answer these questions. She has no bias in this case. While she was initially upset because the defendant was cheating and leaving, she told you, I forgot all about that when Naomi told me what happened. Ashley Cremines, the expert from the Marison Clinic at Children's Hospital, was a third witness, and she's been trained in the correct way to interview a victim, and there's no allegation that she did anything that was not correct. She has no interest or bias in this case. She's simply doing her job. After Ashley, you heard from Naomi's friends and their parents, Adam, Lily, Hallie, Kylie, and Denise. Now, these are people that did not ask to be drugged into this mess. In fact, some of them were contacted by law enforcement. These are people who had a front row seat to the controlling nature of this defendant. They're people who Naomi was talking to about sex when she was 9 years old. They're people who were uncomfortable with the defendant being around their children. People who tried to step in and do the right thing. None of them has an interest or bias in the case. They simply related to you what they saw and what they heard. Again, none of them had anything to gain by testifying in the case, other than to stop the rapes of Naomi. Very fascinating, the defense's cross of Denise Faber specifically. The defense actually tried to blame Denise, the parent who called the school, for not reporting her concerns to someone else. It's her fault. But she did what all parents should do. She called the school. She made a report. The fact that the school did nothing, that's not Denise's fault. The fact that the abuse went on after Naomi was in the 4th grade. The school didn't follow protocol. It's not Denise's fault. She did what she should have done. Finally, you heard from Detective Antonor. Again, Detective Antonor, no interest or bias. His job is independent on cases. He simply related the facts and the evidence as he collected it and as he learned about it. Again, Detective Antonor is just doing his job. Well, let's talk about the defense witness, Aaron Ludwig himself. Now, if there is anyone in this case that has a reason to lie to you, it's this man. He called his daughter a liar. In fact, she is never to be trusted again because one time she went somewhere without permission for between 1 and 3 hours. This is his only defense. She's a liar forever because she snuck off one time when she was 16 and a half years old. I mean, frankly, that's ridiculous. This man has a family, but you heard his testimony. Basically, they are lucky to have him. It's his house, not the family's house. He had vacations, not family vacations. When he did go on family vacations, he had to pay for the whole thing. Poor Aaron. He even compared himself to his friends who have no families. And honestly, it's not that far of a leap for him to do that because he doesn't look at Marnie, Naomi, and Max as family. They are possessions. They are objects. This man who continues to blame Marnie who needed to go to the gym. Marnie, you're not fat, but you need to go to the gym. Complains because Marnie wasn't at the door waiting for him when he got home from Brazil. Yeah, she works third shift, but she needs to be at the door when I get home. Really, it's nonsense. He's blaming her here today. It's her fault. But let's keep in mind that he's already talking to another woman. He doesn't care. And he had just met this woman in December. It's awful convenient that he was just there in October. He's home for a month and flies right back down in December. Then, if his daughter's a liar because she snuck off at 16 and a half years old for 1 to 3 hours, what does that say for the adulterer? Certainly someone who cheats on their family is more of a liar than a 16-year-old who goes missing for 1 to 3 hours. The defendant's reaction to his daughter being missing really seemed more to be about the fact that she was disobeying than the fact that he didn't know where she was. You don't dare disobey. And the defendant was able to muster up a few tears for his grandmother. But did he have those tears for Naomi when she was on the stand crying? Did he have those tears for Marnie when she was crying yesterday? Did he have those tears when he stared at that video screen while his daughter relived the rapes that she went through and was bawling? He didn't have any of those tears for his family, for his daughter. Honestly, again, no one has more interest or bias in this case than this man right here. He is the person with the motive to lie. And perjury, it's just not that big of a deal to a child rapist. Now, the defense has gone to great lengths to make you believe that Naomi made the entire story up. 8 years of sexual, mental, and emotional abuse just because she was angry at her father, because he was cheating and was leaving Marnie for another woman. Or maybe she was lying because she couldn't have a boyfriend. They could make up their mind why she was lying, but she must be lying. Well, if Naomi was lying to keep the defendant home, wouldn't she have gone to him and threatened him first? Hey, if you leave and if you cheat on my mom and you run off with another woman, I'm going to tell people this. That's what would have made sense. It didn't happen because it's not true. And if she didn't want him in the house so that she could have a boyfriend, why not just let him go? Go to Brazil. Because that's not true either. It's not true because it's not made up. She was raped. The defense's theories of her lying fall flat. They don't make sense. The problem with both of these theories is that Naomi was talking about laying naked with her dad and white stuff coming out when she was 9 years old. She was telling her classmates that she had to do stuff with her dad until white stuff came out and then she was finished. It's more likely that Naomi told her mom about the rapes because she finally felt safe enough to tell. Lily told her, no matter what, I promise you, your hell ends today. I will make you safe no matter what I have to do. Remember what the expert Ashley Cummings told you. It's very common for children to wait for years to disclose, if they ever disclose. Bottom line, Every victim handles rapes differently. And no one can judge when a person should tell, how a person should tell, or who the person should tell. We don't know until we've been there. Now, the defense has gone to great lengths to point out not a drop of physical evidence in this case. They want DNA, they want rape kits, they want fingerprints. This isn't Law and Order SVU, where the victim is raped and runs straight to the hospital emergency room so they can scrape under their fingernails and do a rape kit and bring in a photo lineup. This is real life. This isn't the 44-minute fake TV we talked about yesterday morning. Disclosure is a process. What DNA evidence would be available years after the last sexual assault? Don't fall into the CSI burden of proof. It's not going to work. When Mr. Ring told you in his opening that there would not be a bit of physical evidence, he misled you. There is physical evidence available. There is the camera that the defendant used to record him having anal sex with his 11 or 12-year-old daughter. There are videotapes that Detective Antonor told you he reviewed and could tell had been recorded over, just as Naomi told you. There is a corset and a skirt that the defendant bought for Marnie and she was forced to wear when they had sex. And when it didn't fit her anymore, he made Naomi wear it. And where was it found? It was found in his closet. This is his stuff. Remember Naomi's reaction when we tried to hand her State's Exhibit 2 yesterday? She literally was repulsed. Don't make me touch that. Do I have to touch it? She literally moved backwards. Now, that is evidence, and you saw it. There's overwhelming circumstantial evidence. Remember, circumstantial evidence is your ability to draw an inference from something. And I gave you the example yesterday of the snow on Christmas Eve. No snow on Christmas Eve, it snows Christmas morning. You can draw this. It's circumstantial evidence that it snowed. Remember how Naomi could specifically recall the blue chair, the TV in the living room, or in the bedroom rather, a Korean pop song by Black and White playing on the TV, the corner of the bedroom, taking 14-year-old Naomi to buy thongs that he kept in his closet, the defendant insisting that his 14-year-old daughter, who had no freedom, be put on birth control, a 9-year-old little girl humping her friends at a birthday party, and touching them like she did her dad, a 9-year-old little girl talking about white stuff coming from her father's penis. All of that stuff is circumstantial evidence this little girl was raped. And you can draw the inference, and from that inference, find this man guilty. Let's look at this. The defendant worked odd jobs until 2018 when he started working at Airborne. In 2018, he went to work and began saving money so that he could start traveling by himself, not with his family. He did his traveling alone, even when Marnie asked to go. No, you're not going. I'm going alone. Look what else happened in 2018. Naomi turned 14 years old. And what happened when Naomi turned 14? Shortly thereafter, she started her period. She's no longer a viable victim for this defendant. So he began traveling to other countries. And what does he do in other countries? We know he meets women. And we know this because he told Marnie he had met another woman. He had another woman. He admitted that today. Think about Naomi's life growing up. Her friends aren't allowed to spend the night with her after the 4th grade. When she starts telling them what she has to do, all the parents are like, no more. You can't, none of her friends can spend the night anymore. Her friends were afraid of the defendant. Hallie spent the night sometime before they were in the 4th, but after Naomi talked about laying naked with her dad, Hallie didn't spend the night anymore. She told you she was afraid of the defendant. In fact, Hallie saw the defendant's temper one time when she spent the night. And the defendant became enraged because the girls weren't asleep yet. They're little girls, and they kept going to the bathroom. Bad kids. And then he came into the bedroom and he grabbed Naomi out of bed and drug her down the stairs, and she wasn't allowed to come back up. Naomi was even afraid to take a shower in her own home. During the interview with Ashley, she said that when she was in the shower, she wouldn't close her eyes because this defendant would come into the bathroom and watch her. And Naomi was growing up and watching her mom be completely submissive to this man. Marnie admitted that there were sexual things she didn't want to do, but the defendant wanted her to do it, and she did because he was the man of the house. If Naomi wanted to go somewhere, Marnie couldn't give her permission. The defendant had to give permission. Marnie told you she always did what he said because that's how she was raised. That's her culture. Obeying this man is all that Naomi knows. When Naomi wanted to go to a homecoming dance, the defendant watched her the entire time. She couldn't dance because he's standing there watching. Naomi told you that she and Max stayed in their rooms all the time because they didn't want to make the defendant mad. When Naomi didn't beat a certain girl in cross country, she got into trouble by the defendant. He demanded perfection of her. And what did Marnie tell you about Naomi? She's a people pleaser. Now let's look at the elements of the crimes alleged and the evidence and testimony that proves each of these crimes. Remember what I told you in voir dire. I only have to prove each element of the offense. If I didn't prove the temperature on one of the days, it doesn't matter because that's not an element of the offense. If I don't prove what color socks the defendant was wearing when he raped Naomi when she was 6, it doesn't matter because that's not an element of the offense. So starting with count 1, rape of a child under 6. Rape of a child under 13 and being under 10. In order to prove rape, the state must prove that during the period of June 1st through December 31st, 2010 in Highland County, Ohio, the defendant engaged in sexual conduct with his 6-year-old daughter, Naomi Ludwig. The defendant and the family lived in apartment 4 in Leesburg, Highland County, Ohio, and this rape occurred in their home. These are the elements. The defendant did, on or about the period of June 1st through December 31st in Highland County. We know where they lived. There's no not even contesting that. Engaged in sexual conduct with Naomi. Sexual conduct means, and it gives you a big definition, but you can just go down. We don't have to prove each thing, anything in the definition. And without privilege to do so, the insertion, however slight, of any part of the body into the vaginal or anal opening of another. He put his fingers in her vagina on the blue chair. Naomi was not the spouse of the defendant. She testified she's not married. He's her father. Naomi was less than 13 years of age. You'll have this to tell you the age, where they were living, and what grade school she was in. On the bottom of the verdict form, there's an additional finding. It'll say, if the verdict is guilty, Naomi was or was not less than 10 years of age. She was less than 10 in the blue chair. She was 6. So you circled was less than 10. Count 2, rape of a child under 13 and under 10. In order to prove rape in count 2, the state must prove during the period of January 1st, 2011 through December 31st, 2011 in Highland County, Ohio, the defendant engaged in sexual conduct with a 7-year-old daughter in Highland County. Again, the family lived at apartment 4 in Leesburg in Highland County. Sexual conduct includes vaginal intercourse. There's no question when the defendant put his penis into Naomi's vagina and she cried out in pain, and the defendant yelled at her for crying, and so she quietly cried and stared at the big gray television in the room. The defendant was raping his daughter. Again, sexual conduct means vaginal intercourse between a male and a female. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. And again, we know she was 7 years old. She told you that she was in the 2nd grade. You have the words to follow along with. So Naomi was less than 10 years old at the time I raped her. And again, that's the rape that she talks about staring at the TV. Count 3, rape of a child under 13 and under 10. And in order to prove this rape, on or about the period of January 1st, 2012, continuing through December 31st, 2012, in Highland County, Ohio, the defendant engaged in sexual
Sexual conduct is defined as anal sex. Anal intercourse. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. When the defendant continued to try to penetrate his small daughter vaginally and then forced her to have anal sex, promising he would just put the tip in, he raped his daughter. And remember what Naomi's testimony was. And I asked her, I needed it. That I knew that it would go faster. That rape would be over faster. Imagine being 8 years old and thinking that's better than it lasting for 1 minute. That's no position for me to go to a little baby. And again, she's 8. So she was less than 10. Count 4, rape of the child under 13 and under 10. In order to prove rape, count 4, the state has proved that during the period of January 1st through December 31st, the defendant engaged in sexual conduct with his 9-year-old daughter. When Naomi was in the 4th grade, the family moved to the Church Street address where they live now, and this occurred in the defendant's bedroom. Sexual conduct is defined as fellatio, which is oral sex or condoning. A sexual act committed with the penis in the mouth. There's no question that Naomi repeatedly complained about the pain that the defendant was inflicting on her. He took her to the corner of the bedroom and made her kneel and take his penis in her mouth. He was raping her by forcing her to perform oral sex on him. Again, she was under 13 and under 10. She was 9 years old. She was under 10 when this happened. Now, the rapes continued throughout middle school time, but rather than have her relive each rape that she could remember, we moved to count 5, the last time the defendant raped his daughter. In order to prove count 5, the state must prove that by force or threat of force, the defendant engaged in sexual conduct with his 14-year-old daughter. Again, the family was living on Church Street, Highland County. Naomi had started her period by this time and thought she was safe from any more rapes by her father. But one day he called her to the couch while he was listening to a Korean pop song on television. He ordered her to take off her clothes, and for the first time in 8 years, he put on a condom, and then he forced her to have anal sex with him. Again, sexual conduct means anal intercourse. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. The defendant purposely compelled Naomi to submit by force or threat of force. Force means any violence, compulsion, or constraint physically exerted by any means against a person or a thing. Threat includes a direct or indirect threat. So, again, this isn't the rape where the man's holding the knife for her in the alley. But let's look at the family dynamic here. This defendant gives permission for everything. You don't do anything in that house until he says it's okay. Marnie is not allowed to give permission for the girls to do anything. She has to send them to him. He is the man of the house. I am the man of the house. I will get what I want. I will do what I want. This is my house. Those girls stayed in their bedrooms from the time they got home from school until the next morning when they went to school because they didn't want to upset him. He had a temper. Everyone spoke of him having a temper. Hallie witnessed his temper when she saw him grab little Naomi up by the arm and drag her downstairs. And look at the size difference between Naomi and the defendant. You saw her yesterday testify. You saw her in the office stand, 4'9", 90 pounds maybe. It's a huge difference between her and this aircraft mechanic who, works on these huge planes, so must be strong enough to deal with those parts. And that's how she looks today. Imagine 3 years ago, or when she was 6. While the state is not required to prove motive, we further motive for Marnie. She told you the defendant complained about her and their sexual relationship. She didn't want to do things he wanted her to do. Then she gained weight, and he complained she was too fat. But who in the house fits his type? Naomi. She's exactly Marnie, but small. And that's what he wanted. He wants small, weak, easily controlled.
and Naomi is the ultimate people pleaser. The state must prove each of the elements of the crimes beyond a reasonable doubt. Reasonable doubt is doubt based on reason and common sense, and you can equate this to the decisions you make in your everyday life. Let's talk about buying a car. Say you want a red SUV, and you find one, and the odometer says it has 60,000 miles, and the payments will be about $300 a month. Your budget allows for a payment of $350 a month. It's everything that you want in a vehicle. All the evidence points to you buying this car. Now, there is some remote possible doubt that this isn't the perfect SUV for you, but reasonable doubt, doubt based on reason and common sense, that has been overcome. And of course, you buy the car. It's not your job to look for reasonable doubt. If it exists, it will present itself from the evidence. In this case, reasonable doubt, doubt based on reason and common sense, that's been overcome, and the state has proven each element of the crimes charged. And as such, the defendant is guilty. At the end of the day, the case is not about whether or not Naomi had a boyfriend. It's not about the defendant having a new girlfriend in Brazil. It's not about where Marnie is allowed to move or if she's allowed to stay in the house. What it is about is a little girl being subjected to a nightmare life from the age of 6 through 14. It's about a little girl focusing on a blue recliner as her father raped her with his fingers. It's about a little girl focusing on the television in her parents' bedroom as she quietly cried while her father inserted his penis into her vagina and told her to quit her crying. It's about a little girl whose father put his penis in her anus, promising only to put the tip in, and that little girl hating it, but realizing it meant that the rape would be over faster. It's about a little girl who was forced to kneel in the corner of a bedroom to perform oral sex on her father, and then finish him with her hand. It's about a little girl who would hear her father tell her she was a good girl while he lived out his sexual fantasies with her. It's about a little girl who's forced to wear an outfit that was bought for her mother when she is raped by her father. It's about a little girl that is raped by her father on the couch after she starts her period while she focuses on a Korean pop song playing in the background. And it's about a little girl who told her friends about laying naked in bed with her father until white stuff came out, 8 years before she was strong enough to tell her mom. Ladies and gentlemen, this is what this case is about, that little girl. The system failed Naomi Ludwig when she was 9, when Denise Faber reported her concerns to the school and the school didn't talk to Naomi. Do not be a part of a system that fails her again. Find this man guilty of all counts and stop Naomi's nightmare today. Thank you.
All right, ladies and gentlemen of the jury, you've heard the closing arguments of counsel, which, as I instructed you previously, instruct you again, are not evidence. Now, I'll now instruct you on how to conduct your deliberations and prepare your verdicts once you've reached them. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all the evidence and decide all the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so the state and defendant will feel that their case was fairly and impartially tried. Now, you may not discuss or consider the subject of punishment. Your duty is confined to deciding the guilt or innocence of the defendant. In the event that you make a finding of guilty, the duty to decide punishment is placed by law upon the court. Now, if during the course of the trial the court has said or done anything which you consider an indication, in my view, of the facts or the case in general, you're instructed to disregard it. All judges must be, and I sincerely desire to be, impartial in presiding over any case with or without a jury, because under the law, the court has no right to invade the province of the jury by indicating a preference between the parties, and the court in this case has not done so. And I just make that comment because don't want it. Sometimes people get the idea that, well, the way the judge is ruling is kind of telling us what way the case ought to go, and that's not at all it. My rulings are based upon the law and the information presented to me, and has no indication as to any preference between either side. Now, your initial conduct upon commencing the deliberations is a matter of great importance. It's not wise to immediately express a determination or insist upon a certain verdict, because your sense of pride is aroused. You may hesitate to change your position, even if you later decide that you may be or you are wrong. Consult with one another, considering each other's views, deliberate with the objective of reaching an agreement if you can do so, without disturbing your individual judgment. Now, you must decide the case for yourself, and you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial, or render a verdict solely because of the opinions of the other jurors. When you go to the jury room, you won't be going to the jury room, you'll be deliberating in the courtroom. Your first function will be to select one of your number as a foreperson. That person that you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. An additional duty of the foreperson is to see the verdict forms and exhibits, and copies of these instructions are returned to the court after you've reached a verdict. And as I've indicated, I'll place in your possession for deliberations the exhibits, the forms, and these instructions. Now, you're going to have exhibits 1 through 7 that are numbered 1 through 7 and 10 and 11. You won't have an 8 or 9, so don't ask, Judge, what did you do with 8 or 9? There is no exhibit 8 or 9 in evidence. 11 is the thumb drive, I believe. It has the Mayerson DVD. If you decide you need to have that replayed, then let the court know, because we'll have to reassemble and have that played by the court for you. Now, until your verdict is announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdicts. Now, this being a criminal case, before it can be said that you've reached a verdict, it is necessary for all 12, I'll repeat that, all 12 of the jurors to agree upon a verdict. Because if you don't have all 12, then you don't have a verdict. Now, as I've said, and in addition to the exhibits, the instructions, you're going to have 5 verdict forms here. I have them prepared. And each of those forms are going to read as follows. We, the jury, having been duly impaneled and sworn, find the defendant, then there's a blank space of rape, a felony of the first degree, as he stands charged in count, and then blank, I've got blank in the instructions, but 1 through 5. And so you'll have 1 verdict form for each count, and you're to insert in the blank space, underneath on each form, there are a couple of asterisks which cause your attention to what you're to do, which is insert guilty or not guilty, so that then the form will be complete. Now, as to counts 1 and 4, if and only if you find the defendant guilty, you're to make an additional finding, which is printed immediately below the language I just read. And it reads that we further find that NL was or was not, those are in parentheses, less than 10 years of age at the time of the commission of the offense. And then, again, if you've made a guilty finding, then you make a finding of that, and you either circle the finding or strike out the one that doesn't apply so that it will read as a complete sentence. Then below that, and I kind of hold it up there, it's kind of hard for you to see where you're at, but there are 12 lines. And again, that's because all 12 of you have to sign each verdict to have a verdict. And unless all 12 sign each verdict, you don't have a verdict as to the count in which there's less than 12 signatures. So each of you will sign your name in ink on that form once you have reached a verdict, and that then will indicate that the signature that you've placed on there is that you can concur in the verdict and that it is your verdict as to that count. Now, once we leave and you are deliberating here in the courtroom, you'll be in charge of the bailiffs. All the doors will be locked. The door to the jury room will be open, so if you need to get coffee or water or use the restroom, you can. Want you to, you can stand up and move around and deliberate. We'll have everything moved out of the courtroom that's not evidence, and all the files and everything, so that you don't have any of that. And then if you need anything, you can just come over here to this door that goes back to chambers and knock on it, and then the bailiff will answer it. And if you have a request or a question, write it down. Don't tell them, because they're not allowed, or ask the bailiffs. They're not allowed to answer any questions or explain anything for you. They're simply permitted to bring your communication to the judge. Then I'll discuss it with the attorneys, and then I'll send you back a response in writing. Now, I'll tell you now that I can't necessarily answer every question that's asked. For example, if someone says, we want to know, what color shirt somebody was wearing at the time of this case. Well, I can't tell you that unless, if it's in the evidence, you 12 will have to collectively remember that. If you can't remember it, or if you didn't find there was any evidence about that, you can't ask for it, because I can't provide you any additional evidence. The case is now complete as to the evidence, and so don't ask me for any evidence that was not that you don't find was present, because I'll just tell you I can't answer that. If you have a question on the law, it's all right here in the instructions, but again, they're extensive, and so if you're having trouble with an issue, just let me know, and again, I will probably just send you back an instruction in writing, or an answer in writing, that will tell you what page to look on and cite the language. And then again, once you've completed your deliberations, knock on the door, inform the bailiff you have a verdict, and then we will reassemble. You'll go back to your assigned seats, and you'll reassemble. Now it's about 10:45, and so you did get here at 8:30, so you can deliberate for a while, and if you feel that you want to take a break for lunch, that's fine. Let us know. During the break, you have to remember the instructions from the court. Now, at that point, you will have been, of course, deliberating and expressing opinions. But if you go out to lunch, leave the building, do not discuss the case with anyone out, and even among other jurors. If 2 or 3 of you go to lunch together, you're not to discuss the case while you're together, because the deliberations have to involve all 12. And we don't want you to go to lunch as a group and discuss it in a restaurant, because, again, that wouldn't be confidential. So you're not to talk about the case in any way, not to communicate about it. You can, again, use your cell phones to text or call somebody, let them know where you're at in the process, but not anything about the case, or make any comments about the deliberations or anything you think about the case in any way. Don't permit anyone to discuss it with you or discuss it in your presence. And just, again, keeping all the instructions that I've said before. Now, again, we're going to collect all your cell phones if you have them, and the bailiff will have those. And again, if you leave during lunch, then the bailiff can give those to you, and then when you come back, it'll be right there by the door waiting to collect them, unless you leave them somewhere else and don't bring them back. All right, now, Ms. Flannery, Ms. West, the alternates. You've sat through this day and a half of proceedings, and as I told you before, and it might be, again, and I understand, I would think it would be disappointing not to be able to deliberate and just express my opinions, having sat through the case, but that's what an alternate does, and you're our insurance policy. So you will not have to remain in the building. You'll be permitted to go back to, if you want to go to work or home, but don't get more than 20 minutes or so away, because and also leave the bailiff your phone numbers where you can be reached by cell phone or immediately, because in the event that something were to happen today during the deliberations and one of the jurors had to be excused, then we would call first Mrs. Flannery and then Ms. West to come in and take that person's place. And so until you've been informed by the bailiff that the jury reached a verdict and the case is complete, you're still under the same instructions: not to talk about it with anyone, not to read anything about it, not to express any opinions about it. Everything I've said during the trial, you're still under all of those obligations until the bailiff informs you that we've reached a verdict, that the jury has reached a verdict and it's been accepted by the court. And I will tell you that, and it'll be 13 years I've been judge in a couple of weeks, and I've had that happen twice. And so, that's why we do have insurance policies, because I've had cases where I had a case one time when I was a prosecutor where it was a long case, I think a week or 10 days, and we had 3 alternates, and we lost 2 in one morning. So it does happen, and that's why we have alternates, just to make sure that the case, everything hasn't gone to waste, and we have to start up and do it all over again. So your service is greatly appreciated. It is very important, and again, you're not yet done. So you may go ahead and come over here and give the phone numbers, if you would, to the clerk, and he and the bailiff will make sure we get in touch with you. Oh, I see Mr. Reno's over there, too. You can give him to Mr. Reno. And then the bailiffs will come around and collect all of your cell phones. Is there anything else from counsel?
No approach.
All right. Yes. counsel, would you come back? All right. Then at this time, counsel and parties will vacate, take all of the evidence, and accept those that are admitted, or not all of your files and so forth. The exhibits, you have exhibits here, or put them back there if you would, Mrs. Collins.
They're in the box.
All right. And then here's the forms and instructions for the jury. Also, my computer will be in here, but you're not permitted to access it, so it will just be closed. So. What? Oh, yes, yeah, thank you.
Please rise.